everyone, welcome to another video of the playlist Patent Agent Exam 2025. In this playlist, we are discussing how the sections of the Indian Patents Act 1970 should be interpreted and which sections are very critical for the exam. We are also discussing the latest amendments to the Act and the rules, which again are very important from exam point of view. Follow our Instagram channel today. The link is in the description. The quiz that is currently running on our Instagram channel can be a check for you if you are on the right track and what is the readiness for the exam. So without further ado, let's start with the section. Okay, let's begin with chapter 7, that is provisions or secrecy of certain inventions. Before we start with this, if you're wondering what happened to sections 21, 26 and 28, please stay till the end of this video. Now, what is this chapter all about? We saw that under normal circumstances, a patent application gets published after 18 months if a request for early publication has not been filed by the patent applicant in Form 9. If so, the patent application gets published as soon as possible. However, under certain special circumstances, if the invention that is covered by the patent application relates to the defense services or can be used by the Indian military, then such a patent application is referred by the controller to the central government so that it can determine if the invention covered by the patent application will be prejudicial to the defense of India. If yes, then the publication of such a patent application is prohibited or restricted under Secrecy Directions and will not be disclosed to the public until the Secrecy Directions have been lifted. Now, before we see what the sections of this chapter entail, let's have a look at what kind of defense-related inventions are we actually talking about. On the screen, you can see 3 inventions which we all are pretty aware of, and even if you are not, go watch the movie Fighter and you will know how they are used. Now, I hope you all are aware of patent classification systems and how they are used for the purpose of categorization of patents. If not, you can go to LinkedIn and check out my posts, or I can also make a separate video on that. Just drop a comment if you want that video and that will let us know. So, the central government provides a list of classes of defense-related inventions to the controller, and if any of the patent applications seems to cover an invention from those classes, they need to be examined well and sent to the central government to determine if the publication is to be put on hold. To give an idea, on the screen are patent classes pertaining to defense-related inventions from International Patent Classification or IPC. Now, instead of going section by section, let's take a different approach this time and see how a patent application covering a defense-related invention undergoes prosecution in the Indian Patent Office. Step 1. Inventor files a patent application with the Indian Patent Office. Next, the patent examiner evaluates the application for sensitive or defense-related content. If yes, the patent examiner notifies the controller and he then restricts or prohibits the publication of information under Section 35(1). Next, the controller of patents refers the application to the central government to see if the publication of the invention would be prejudicial to the defense of India. If yes, the secrecy directions are maintained, and if not, they can be revoked and the applicant is notified accordingly. It might also happen that if the controller does not give secrecy directions for an invention, but the central government feels that the invention is relevant for defense purposes, it can notify the controller to that effect, and the secrecy directions will be imposed by the controller under Section 35(3). Under Section 36, these secrecy directions are reconsidered by the central government after every 6 months, or if a request is made by the applicant to do so. The central government will see if the publication of such information will still be prejudicial to the defense of India, or in case of an application filed by foreign applicant is found that then the invention is published outside India, it will ask controller to revoke the secrecy direction, because now it doesn't make sense. The invention is already out in the public. If the controller decides to revoke the secrecy directions under Section 36(2), then the applicant of the patent application will be notified within 15 days of the receipt of the notice by the controller from the central government under Rule 72. Coming to Section 37, the consequences of secrecy directions. Now, as long as the secrecy directions are in force, first, the controller cannot refuse or reject the patent application. Second, there cannot be any appeal against the order of secrecy directions by the controller. Now, if the central government uses the invention while the secrecy directions are in force, the patent shall be treated as a granted patent under Section 36(2)(b). A solatium or compensation will be provided to the patent applicant based on the potential profits. We know that a renewal fee is to be paid by a patent applicant for any granted patent every year until the term of the patent expires. However, if the secrecy directions were imposed on the patent application, the patent applicant need not to pay any renewal fees until the secrecy directions were in force. This comes under section 37(3). Let's come to section 39. This section mainly covers foreign filing license. This section mainly applies to the people who are residents of India and have developed the invention in India, but also want to file patent application for the same invention outside India as well. Now let's see, when does a patent applicant need a written permit or a foreign filing license in Form 25 from the controller. First, if he is a resident of India or one of the joint applicants is a resident of India who wants to file a patent application outside India and 6 weeks from the filing of Indian patent application have not elapsed. Second, if secrecy directions were imposed on his patent application. Third, no patent application was filed in India. Now, Rule 71 applies here. Under Section 39(2), the controller shall dispose of every such application in 21 days from the date of filing of request for foreign filing license, or where the invention is related to defense or atomic energy. The period of 21 days shall be counted from the date of receipt of consent from the central government. Now, Section 39(3) says that this section is not applicable to non-resident Indians or NRIs. Sections 40, 41 and 42 are pretty straightforward. However, if you face any difficulty in understanding them, please do not hesitate to write to us by commenting down below and we will reach out to you immediately. Section 21 will be explained in a YouTube Shorts video and will be out on Friday, whereas sections 26 and 28 will be covered in our next blog, which will be published on the website on Monday.